So who got zucked today? Yes, we're talking about being deplatformed. We're talking about getting thrown into Facebook jail or whatever kind of social media online jail. But here we actually have a Second Amendment company, Armslist, who is fighting back. We're going to take you inside the rings of what this looks like. We're talking about government jawboning. We did a deep dive on government jawboning. That video will be posted in the pinned comment down below, so be sure to check that out. So guys, let's talk about jawboning. Let's talk about Armslist. Let's talk about how we are all being deplatformed and how these lawyers, we're not all bad, but most of us are. Let's talk about how the government, tech companies, and lawyers are jawboning you. Let's get into it. So first, let's meet some of the players. Armslist, of course, if you are unaware of it, runs a website for legal firearm transactions. Again, legal firearm transactions. It's kind of like an eBay for guns. They host the platform. People can kind of post up their ads and then buyer and seller take it from there. Torklist, which is its sister company, does basically the same thing for car parts. Both of these companies are owned by the same individual, which would make sense then about why they're suing together, because they both use Facebook as well as Instagram. Facebook and Instagram, of course, are owned by Meta, which is the same company, to post pro-gun as well as automotive regulation commentary. Then in 2020, Facebook and Instagram banned their accounts, even blocking armslist.com in private messages and throttling Torklist viability. What is throttling? Throttling is super important. You see, the way that you see this video right now, if you're not a subscriber, and if you're not, shame on you, but otherwise you probably found it because it was shared on your home page. Okay, when you signed into YouTube, maybe it was a suggested video. So how does it get into that algorithm? There's a bunch of different things, won't bore you on it. You can search for it on your own. But what happens if a company, whether it's YouTube or in this case, Facebook, kind of puts their thumb on the scale and take you out of the visibility for the public? That, in essence, low resolution as it is throttling. So Armslist sued, claiming that this violated their free speech rights under Pennsylvania's Constitution, specifically Article 1, Section 7. They wanted a court order to get them back on the platforms. Now, Armslist's main argument was that Facebook as well as Instagram were not acting alone. This is where it gets more interesting. That instead they were, in essence, puppets of federal lawmakers, jawboning them into anti-gun censorship. Jawboning, and we did a whole video on that. Hopefully you can find the link popping up right there. You can also find it linked in the description box and pinned in the comments down below. Really quickly, jawboning is when the government basically acts like the mafia, pressuring companies, private companies, to suppress speech without ever having to pass laws. Think of the playground bully suggesting that you hand over your lunch money. Armslist said congressional letters and threats created a hostile regulatory atmosphere that forced Facebook to deplatform them. They leaned on a recent United States Supreme Court case that we've covered elsewhere. And we cover that in the same jawboning video, NRA versus Vulo from 2024, where the Supreme Court said that government coercion through third parties can violate the First Amendment. Now let's dig into these letters, because this is where it gets spicy, because they're the backbone of the Armslist case. First up, a 2016 letter from Senator Edward Markey to Mark Zuckerberg. If you've been living underneath a rock, Mark Zuckerberg is Facebook and Meta, Instagram CEO, all that kind of stuff, okay? Senator Markey wrote, quote, in part, "I remain deeply concerned that gun sales on Facebook and Instagram may circumvent or violate state and federal laws," period. He noted, without any evidence that this is always happening, all that kind of stuff. He urged them to, quote, "prohibit postings for firearm sales," end quote, to make communities safer. Ah, there it is. Do it for the children. The pearl-clutching Maud Flanders approach. Because, hey, if there's one way around the Constitution, it's fear-mongering. Please excuse this brief interruption to support our sponsor. Our sponsor today is my law firm. We've got over 50 employees, over 30 attorneys, all over the state of Wisconsin. We are here in the state of Wisconsin. We handle criminal defense, divorce, and we also have estate planning. Different wings of the firm do different things to make sure that you always get the best attorney at a price point that you can afford. And if you're enjoying this and other educational legal content that I've done, well, thank you for joining me, number one. But number two, please consider dropping a 5-star review. You can find posts down that will be linked to different Google platforms. You can check out some of the details below. I appreciate you sticking around. Don't miss the quote of the day at the end of the video. Now back to the show. Armslist argued this wasn't a friendly suggestion being made by a concerned citizen, but instead a senator, a U.S. senator, flexing his influence, hinting at regulatory trouble if Facebook somehow brazenly failed to comply. So one letter, okay, that's a data point, but that's not really what's going on here. There's no jawboning with just one letter. So in 2018, then Senator Dianne Feinstein criticized Facebook for not censoring enough posts and, per the complaint, quote, threatened more robust federal regulation, end quote, if Facebook did not step up to censor more. She sat on committees that could push laws like amending Section 230 of the Communications Decency Act, which is very important because Section 230 shields platforms from liability for user content. In other words, if you go out and if you post something horrible and illegal on Facebook, you may not be able to sue Facebook, or a different company may not be able to sue Facebook over it, okay? As long as there's guardrails, all that kind of stuff. But you get the gist to it here, okay? Otherwise, we could never have any place where someone could post anything online because there's always someone out there that's going to ruin it. Armslist said this was a clear message. Censor gun content or lose your legal protections. They framed Feinstein's words as, fix this or we'll fix it for you. In February 2020, right when Armslist accounts were banned, 13 United States senators sent another letter to Zuckerberg. They said this time that banning direct gun sales wasn't enough. Facebook needed to suspend accounts violating these policies and stop users from dodging bans by creating new groups or using apps like WhatsApp, also owned by Facebook. They asked, quote, what proactive measures are you taking, end quote. That's the equivalent of just always perpetually moving the goalposts. That's what that is. Because if anything's happening, you are not being proactive enough. Armslist argued this was a demand for aggressive enforcement, implying consequences if Facebook didn't crack down on gun-related content. Finally, in March of 2021, 23 members of Congress wrote to Zuckerberg demanding Facebook, quote, immediately examine its advertising policies, end quote, to avoid firearm ads that promote violence. Later that year, Senators Feinstein, Whitehouse, and Blumenthal announced legislation targeting Armslist's Section 230 immunity, aiming to make platforms like Armslist liable for their user transactions. Armslist said these actions, though after the bans, showed a pattern of congressional pressure that understandably intimidated and scared Facebook into silencing them. Armslist's second argument was that Facebook and Instagram are basically de facto public forums, like modern town squares, just happening in a digital rather than a physical environment, where free speech rights ought to apply. They cited a case called Commonwealth versus Tate from 1981, where Pennsylvania's Supreme Court protected speech on private college property open to the public. Armslist pointed to Facebook's mission to build community and Instagram's goal to be a place of expression, arguing that these platforms invite public discourse, so banning their pro-gun speech was therefore unconstitutional. So that's Armslist's side. What did Zuckerberg have to say about it? Well, Facebook and Instagram fired back hard. They said, we're private companies, not the government, and the Pennsylvania Constitution only limits state action. In other words, it only limits government action. And they argued that Armslist failed to show that they were actually indeed coerced into banning the accounts. So even though Armslist could show the shove coming from Congress, Facebook basically argued that, look, you have to say that the shove caused the fall being the banning. And you have to remember, for stuff like this, it's very difficult to figure out the causality. That's exactly what the tech company here is arguing. You have government action, and then you have tech company output. But how do you connect the causality here? Facebook went on to frame and to dismiss the congressional letters as non-threatening, just more like public criticism than a mob boss's ultimatum. The senator's letter didn't mention penalties after all, and Feinstein's 2018 threat was vague and unrelated to specifically Armslist content. The 2020 and 2021 letters either followed existing policies or came too late to cause the bans because they had already gone into effect. The proposed legislation that was underway, just talk, not law. and not directed at Facebook. On the public forum argument, Facebook and Instagram said that their platforms are not town squares. They're private businesses, just with their rules, like any other private business. Their terms of service allow them to remove content or accounts to protect their community, like a nightclub bouncer ejecting a rowdy guest, for instance. They argue that Tate only applied to criminal trespass cases, not civil disputes like this. So you see the distinction between criminal and civil law. They also cited to another Pennsylvania case from 1986, which stood for the premise that confirming private property is not a free speech free-for-all. So what did the Pennsylvania court do? Well, number one, it's important to understand where we are. Most states are the same. There's something like a trial court, different places, different states call these courts different things. And then up from there, you get to some sort of intermediate court of appeals. And then above that, you get to the state Supreme Court. And then above the state Supreme Court, you get to the United States Supreme Court. So those are kind of your levels. And sometimes some states will have little municipal courts below the kind of the state trial court. So maybe the town or village municipal court, right? And then you get to your state court, usually organized by county. And then you get to your intermediate courts of appeals and so on. This is happening in the Pennsylvania Superior Court, which I'm no Pennsylvania attorney, but a quick Google search told me that this was the Intermediate Court of Appeal for Pennsylvania. And in short, the Pennsylvania Superior Court sided with Facebook. Kind of unsurprising. On the coercion claim, they applied the NRA versus Vullo's test, and they arrived at the conclusion that the government action must be a clear threat of adverse consequences. The letters fall short of being clear. The senator's tone was, hey, polite, not menacing. Senator Feinstein's 2018 threat was too distant from the 2020 bans, as well as lacking specifics. The 2020 letter suggested Facebook already had anti-gun policies, therefore undermining the coercion angle, and the 2020 actions came after the bans, too late to matter. Crucially, the court noted that Armslist claimed federal pressure, but Pennsylvania's constitution only checks state power. In the court's view, a fatal mismatch. On the public forum claim, I know a lot of you would be curious about this, the court ruled that Tate did not apply. Tate involved a college open to the public with a statutory defense to trespass, not a private platform with strict content rules. Western Pennsylvania 2, that's that 1986 claim that basically clarified the free speech free-for-all, clarified that private property isn't a public forum unless the government's involved, which maybe it's involved with these letters, don't know. Facebook and Instagram's curated spaces, there's a term for you, curated spaces, governed by algorithms and policies, are not open mic nights. So at the end of the day, the court dismissed Armslist's case, saying that their allegations did not meet Pennsylvania's fact pleading standard. No discovery was allowed. And by the way, the discovery is important because that's exactly how Armslist would prove that causality, the causality that would link the government action to what the tech companies did, right? So no discovery. You see how this game is played? Hey, you can't prove that the government, when it did this, caused that, and we're not going to let you go digging for it. This case shows how hard it is to prove jawboning without clear threats and highlighting the private nature of social media. This goes to show you how pervasive jawboning can be. Basically, unless you have a significant government agent misstep, where they just say something really stupid out loud publicly, it's going to be really dang hard to catch these cases, like the Supreme Court NRA versus Vullo one. But that doesn't mean that we have to stop trying. I'm sure this case is going to be appealed. Let me know if you want me to stay on top of this. We'll see where it goes from here, presumably to the Pennsylvania Supreme Court. Let me know. We're going to close with our ever popular quote of the day. Be sure to hit that like button if you've not already done so. And as always, drop a comment down below. Where do you think this case is going? And how common do you think jawboning actually is, whether in the Second Amendment space or elsewhere? This one comes from noted German thinker philosopher Immanuel Kant, who wrote in 1784, quote, "Dare to know, have the courage to use your own understanding." End quote. And your own understanding, oftentimes, this is very Kantian, can only be as good as the lenses through which you perceive the world. Part of that is informed by education, which is why these jawboning battles are so important. We have to get information out there. I appreciate you sticking around, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.